It's always advisable to have an employment contract. However, there's no legal requirement that an employer and an employee have an employment contract. Section 29 of the Basic Conditions of Employment Act does state that there's certain written particulars that an employer is required to provide to the employee. Those written particulars would include the details regarding the employer, details regarding the employee, all details regarding remuneration, as well as any other details regarding the nature of the employment relationship, such as commencement date, termination periods, leave that the employer would be due, and a number of other aspects that you would find in Section 29.
Well, firstly, an employment contract is important because it regulates the terms and conditions of employment. It also assists in setting out the boundaries of the employment relationship and detailing to both the employer and the employee what is required insofar as it relates to the terms of service. In addition, it can assist in reducing any disputes that arise between the employer and the employee because it sets out the basis of which the person is employed. So if you set that out in terms of the four corners of an employment contract, there should be no disputes, which could then in turn lead to a reduction in dispute resolution hours in terms of your employment relationship.
In the case of no employment contract, the relationship isn't null and void. What would happen then is that the employer and the employee would have tacitly agreed to certain terms and conditions of employment. This, of course, can lead to ambiguity, which can lead to costly disputes. In an instance like this, what you would find is that the Basic Conditions of Employment Act, as well as the Labour Relations Act and any other applicable legislation and common law would then govern the relationship.
There are a number of manners in which to terminate an employment contract, the most common being the resignation by the employee. Next would be the death of the employee, which is obviously self-evident. The employer may also terminate the employment contract at its instance due to the misconduct of the employee, incapacity or operational requirements. An employee and employer may mutually terminate an employment contract, and a fixed-term employment contract may be terminated due to the affliction of time, alternatively due to the completion of a specified project.